Can I say happy belated birthday if that's what that is?
Oh, no. There's no, not birthday, no.
Well, happy whatever.
All right.
Right off the bat, we're thrown into courtroom chaos, no formalities, no clean transitions. Just a judge trying to reset the tone. But notice this, competency is mentioned immediately. That's not casual, it means the court is first deciding whether the defendant is even mentally fit to proceed. High stakes before the case even starts.
All right, thank you very much. All right, so what is the results of the competency disposition?
She is competent, Your Honor.
Okay. All right, do you have all the discovery?
I do, Your Honor.
Was an offer tendered?
Yes, it has. However, it was tendered before the motion for competency. So we were set for today so that we can either talk about whether there's going to be something different.
Well, did you discuss with them?
They haven't shown up, Your Honor. They showed up once, and then they were called to the grand jury.
All right, Norma, call them to come here, please. Does anyone have the number for? All right, they're going to text them.
He has been texting, Your Honor. He's been telling me what's the.
Oh, they're going to text them and say, Judge Boyd would like you here.
That would be awesome.
Yes.
Thank you, Your Honor.
So
Yes.
just have a seat and we're going to get to you.
Thank you, Your Honor.
You're welcome. And Ms. Davis, you're in the center, and defense,
Which side, Your Honor?
you're on this side. No, I'm sorry. Yes, you are. You're on this side.
Any side you like.
No. In my mind, I have to think what the
Cheers.
deputies wanted. And so the deputies do want you on this side.
Okay.
We used to have defense attorneys on this side, but then for security reasons, the deputy asked that you all be moved on this side. It's been a long week for me, even though it's just Monday. The weekend was very long for me. All right, the court is calling 2023 CR 8542, State of Texas versus Michelle Davis. Can I have parties announced for the record for the state? Defense?
Jose Rocha from Michelle Davis, and we're ready, Your Honor.
All right, and are you Miss Davis? Counsel, have you received all of the discovery?
Yes, Your Honor.
And did you review it with your client?
We have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Davis, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
This is the legal lock-in moment. Every "yes ma'am" is building the foundation of a guilty plea. In courtroom terms, this is called a knowing and voluntary waiver. Translation: the court is making sure she can't later say, "I didn't understand what I agreed to."
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor, I do.
State, are you proceeding on the indictment as presented?
We're waiving count 1, Your Honor, and proceeding on count 2, which is a state jail felony theft.
Okay.
That's our understanding here. Yes.
Any objections?
No objections, Your Honor.
All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you understand in count 2 you're charged with the offense of theft $2,500 but less than $30,000?
Yes.
All right. That's a state jail felony. Range of punishment is anywhere from 180 days and up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
All right. Did you understand you have a right to jury trial?
Yes.
This is where the courtroom gets surgical. The judge is methodically stripping away constitutional rights, trial by jury, silence, confrontation of witnesses. And the key phrase here is, intending to give up. That's legally bulletproof language if the plea is challenged later.
A right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent.
Yes, ma'am.
Did you understand by entering this agreement you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
And did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Excuse me, one moment. Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Davis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. There's a $2,000 fine. State recommends deferred adjudication. There's to be restitution of $7,200 to Monticello Custom Homes LP. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the
Yes,
plea?
Your Honor.
State, is that the plea? Did you review the document entitled Waiver of Appeal with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. Did you understand that's a recommendation from the state and the court does not have to follow that recommendation?
Yes, ma'am.
Then to count 2 in the indictment, how do you plead? Guilty, not guilty, or no contest?
Mm.
I'm sorry?
Guilty.
State, any evidence?
Proper states exhibit 1 and its attachments.
No objections, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial?
Yes, ma'am.
A right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent.
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation.
Here's the pivot point. Even without a dramatic trial, the judge is already stating there's enough evidence for guilt. That's critical, because it means the plea isn't just emotional or negotiated, it's legally supported by the record.
Of testimony and stipulations, court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we have reached an agreement on this case, Your Honor. My client, after reviewing all the facts, decided that she would want to move forward with a plea. She understands what's at stake here, and I know that she's going to be successful in completing this deferred adjudication, Your Honor.
All right. Do you have any children?
Adults.
All right. Are you employed?
I can't work. I'm disabled.
And what's your disability?
A whole list of them. A bunch of autoimmune disorders, low scoliosis, spinal disorders, undifferentiated connective tissue disease, bunch of arthritises. I have a whole slew of disorders. They're listed in the paperwork.
All right. So
Your
when did
Honor,
this occur?
I do have documentation that I was provided by my client regarding that if the court were like...
No, I'm just wondering, when did this disorder occur? Did these disorders occur before or after this offense? Or did they...
Before, I was actually on Social Security for mental disabilities and tried getting off, went to college and tried working, and apparently didn't go so well, and I had undiagnosed autoimmune disorders that were affecting me mentally, bodily, and I had emergency spine surgery actually right after that position. It was affecting my body, and then I just had all sorts of messed up stuff going on, Your Honor.
So are you currently receiving SSI?
I'm working to get there. I also didn't have insurance for a while, And so that's what I'm working towards now, because I've been disabled for a long time. I had a doctor actually during this time frame diagnose me with one disability and one autoimmune disorder and didn't tell me. And I had autoimmune disorders before that went undiagnosed, and it's been a hayride since then. So I'm getting all of that taken care of now, getting all my X's and crosses off the box so that I can get on disability. My next stop is neurology, and then back to the neurosurgeon. But I'm going to apply now because there's some extenuating circumstances with recently being cheated on, and so I have no income now and all sorts of other fun stuff.
All right. So how do you support yourself?
Working on that now. My mom lives with me and I take care of her. She's a heart transplant recipient, and so that's the income in the house right now.
Oh.
Yeah, a lot going on right now.
Oh, yes, it is a lot. But how are you taking care of your mom?
She's a heart transplant recipient and she's bedridden, and so I change her diaper, feed her, run her on her doctor's appointments and errands as best I can. And my son, who's mentally handicapped, he's got DID, bipolar, and so I keep his friends in his head in check because I'm a psych major. So I help him, and then he helps me around the house and helps with my mom. We kind of have a triangle thing going.
All right. So what I can tell you is people who are on probation in my court, I don't allow them to be home health care providers.
Well, I'm not her physical, technical home health provider, but I mean, I'm her only help, like unofficial help. She lives with me, and I mean, I have to take care of her. She's my mom. I'm her only person. That's why I'm doing this instead of doing a trial.
I mean, no, here's the thing. If you want a jury trial, you can. But let me just explain something to you. What I've read in the stipulations.
Now we hit tension mode. The defendant is pushing back, claiming coercion and misunderstanding financial evidence. This is the classic courtroom clash, documented stipulations versus personal narrative. And judges rarely ignore written stipulations unless there's overwhelming proof of duress.
Is that you admitted to the owners of taking the money.
And I only did that under duress because they locked me in a room and would not.
Oh, well, here's the thing. If you want a jury trial.
I don't, ma'am.
Because
I don't.
All right, let me explain something to you. Because what I've read in the stipulations is money went to Green Dot Bank account.
And it's not. It's a stash card. I had a bank, a regular bank, which is Techstar Bank. And then I had a stash account, which I actually had, what do you call it? You could even do, sorry, I get brain fog because of all the autoimmune, but it was an actual bank card, and I didn't know it was Green Dot or whatever. It's actually owned by another company now, but it's actual a bank. And
all right, so here's the thing. Monticello Homes, that organization, the people who work for that organization and own it, they say that $800 was going into TxDOT, whatever card, but it wasn't their card. It wasn't for their employee. It wasn't for anything associated with them. It was associated with you, and it was going in your account. Now, if you're telling the court that you did not steal the $800 several times to total $7,200, then we can set it for jury trial, because what they're saying is,
they're saying I did a whole lot of stuff.
well, let me just tell you, the 4 transactions were done in the same manner. They say on July 19th, 2019, it was for $900. On August 2nd, 2019, it was for $2,000. On August 16th, 2019, it was $1,500. On August 30th, 2019, it was for $2,000. That's what they're saying. And they say those transactions were above what you would have been paid. And they said that it went to your account. And the person who's saying that it went to your account was Gregory Martin, who I guess is their financial person. And when he was looking at the billing, that he noticed discrepancies, and that discrepancy went to you. It went to your account. Now, if you're saying that you didn't steal this, then guess what? We can set it for a jury trial.
I don't trust people enough.
And it says here that you signed a statement saying that you overpaid yourself $7,200 and that you're going to pay it back.
How would you feel if 5 men took you from your office, locked you in the back of an office and wouldn't let you leave, wouldn't let you make a phone call, and wouldn't let you do anything until you signed a paper?
Well, what I can tell you is I wasn't there at the time, so I don't know if that occurred or not. What I do know is there's $7,200, and what I'm reading in the stipulations is that that $7,200 went to your account.
Right, and I'm saying, this is why I don't want to have a jury. I don't trust the judgment of people in peers in a jury because, one, they don't want to be there. Two, I don't trust that enough people would understand office. I don't trust anything. I don't trust people. I have severe trust issues. This office, that place was a madhouse. They lied about a lot of things. I mean, I don't want to get into
Oh, no, go
I
ahead.
I
understand.
know, and that's
You
what
can
I'm
tell me.
saying. I used to have to pay the lawyer there for the legal stuff that guy in those offices did. I'm saying,
This is where the case stops being just legal and becomes psychological. The defendant isn't arguing facts anymore, she's arguing distrust in the entire justice system. Ironically, that's exactly why judges push for structured pleas. Emotion can't override evidence in court.
I don't know what we can do for her.
my house is not chaotic, it's calm. It
Let's
just,
see what they have to say.
Judge, whenever someone's granted probation, we have to go through different assessments just on a supervision level. And I think out of one of the assessments that we are mandated to do, it could give us a little bit more information to give you clear direction on what else should be done.
Your Honor, it seems to me that
Just 1 second.
We need to do
I'm sorry.
Just 1 second. Yes, probation.
we need to do the risk assessment
Okay.
for a fact, and that could give us the level in which she should be supervised.
And that was what I was going to be suggesting, Your Honor. I believe that maybe perhaps that would give a better picture to
Oh,
the
just 1 second.
to the court.
Anything else, probation?
I would say that maybe, I know there probably had been some competency issues, or we would ask that we do a mental health evaluation on our part to see if she would fit into that supervision as well.
Mhm. All right. Thank you. This is what the court is going to do. Court is going to sentence you to 4 years deferred adjudication. There's to be restitution of $7,200 and no contact with Monticello Custom Homes LP. There's to be regular reporting by Zoom or in person, regular random UAs, a MIC evaluation, field visits 1 time per month until further notice, and see if probation can check on the occupants of the home and determine how many occupants are actually in the home. And then do the risk assessment for supervision. There's to be no employment related to accounting or any type of money changing hands. You're not allowed to be a cashier. You're not allowed to work with money at all. Do you understand?
Can't wait
to
to.
understand.
Yes, ma'am.
There's to be proof of employment or SSI. Please put on your listening ears. Listen to what I'm saying. There's to be proof of employment or SSI within 45 days. And again, no employment as a home health care provider with minors or any employment as previously stated relating to accounting, cashier jobs, any job that's related to exchanging monies where she's in a position to handle funds. There's to be 100 hours of community service restitution. If for some reason she's unable to do the community service hours, she'll need to provide a letter or proof from a doctor that she can't do any type of community service hours. And there's going to be the theft course. And there's a $2,000 fine, and that will be probated. Probation, is there anything else she needs? Is there anything else you need from the court?
No, ma'am.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right. We can go off the record. In this court, to be successful on probation, communication is key. If there are any issues, let your probation officer know. If you feel as though the probation officer is not addressing those issues, you can always come back to court. Do you understand?
Yes, ma'am.
All right. Anything else you need?
No, ma'am.
All right. Make sure you give those documentation and sign a release of medical information for probation. Okay. All right. Thank you.
May I be excused, Your Honor?
Yes.